Monroe not here?
No, it doesn't appear to be. Okay, I'd like to welcome everyone here. We've already had our karakia this morning, so we did it for both meetings. So we'll just carry on straight through. Any notices?
It's not meeting related, but there is a silver BMW out in the visitors' car park with the back windows down. Go Queensland up here. QA. Just so you know.
Sounds like you, Barry. Grey BM.
Grey BMW?
Yeah, just outside the reception. Yeah, there's a couple of my cousins just cleaning it out now for you.
He'll be fine. It's tapu, that car. Okay. Actually, a special welcome to you, Barry. It's a pleasure to have you along, checking on us here. Okay, so no other notices other than Barry's car has been raided by the local boys. Apologies. So we have an apology from Toro, and we didn't mention that before, but he did notify me. So Toro and Alan Dick. Apologies from Alan Dick. Api and Mati, you are going. We'll just roll. If you have to leave, your apologies are registered for that.
And Liz Monroe.
Apologies from Liz Monroe. Okay. Oh yeah, you're 2 o'clock. Yeah, we're going to be out of here, mate. Okay. So someone to move. Apologies accepted. Paul, Peter, you second. Mover and a seconder. All those in favour? Aye. Are there any conflict of interest? There are thousands, but hopefully that we've all registered them. Any conflict of interest that have not been registered? Oh.
No conflicts of interest, but I'm going to add my apologies, please, Mr. Chair.
I did already.
Oh, good.
Yeah. Are you off now?
Yeah, sorry.
Okay.
I've been checking every 2 minutes.
Take it out of wire off me.
I will. I don't have my apologies, so I've got regional Taki to take care of back in water and I'll need to go. Sorry about that.
You'll be missed, mate. You'll be missed.
Oh, look, I'm missing you all already.
Okay, there are no conflict of interest. Confirmation of the minutes. I'm going to take them as read. Is there any amendments to the minutes? If there's no amendments, is there someone move that they are correct? Janella, and there you second. All those in favour? Aye, the minutes are carried from the previous meeting. Follow-ups from previous regional councils. There are a number I noticed. Tom, you had quite a few I noticed. Yes, do you want to just run through the follow-ups, Tom? Because quite a few were you. Do you want to just take questions on them?
Easy to just take questions, yeah.
Any questions for Tom on the follow-ups? Paul?
Thank you, Chair.
You're not here.
Probably more of a statement than a question, but I had emailed Tom about this particular issue, and it talks. It's number 6, the oil and gas change work program, and the information pack that was circulated by from OPSM. I let Tom know and James know of my disappointment in the content of that particular information pack. I didn't think it quite covered everything that it should, especially around the risks involved in oil and gas exploration. So we're going to attempt to put another information pack sort of thing out so that we can cover those issues.
Yeah, I did note your comment.
And just to add to that, I have been asking every week since we had that meeting, what are the dates for the stakeholder engagement? So it's with extreme disappointment that I finally received notice last night that the Central Hawke's Bay engagement is on Friday. So I've got 2 days with a weekly newspaper, and there's no opportunity for me to be encouraging any engagement in my community with that notice. I'm not at all happy.
We will note this, gentlemen.
Are
Thank
there
you.
any solutions that might be offered?
Look, first of all, apologies because councillor, you had asked for these dates and it hadn't been passed on to the relevant staff, which is why I followed it up yesterday, and it's why you got notification last night. Look, short of us calling another meeting, I'd need to take advice on whether or not possibly we see what the interest is like on Friday and whether it does warrant a further meeting, and whether there are other steps in the process, given this is pre-engagement, that would enable a wider public meeting or the like. So I'll ask Tom to just check with Kerry on that and come back to you.
In the area around the port and the marina in particular. Sorry, the inner harbour, the marina, where the moorings are, the boat, the vessels are tied up basically, because that's the obvious, one of the obvious places where it could have come from, is from people who are living aboard vessels.
Manala, what is the
It's a bacteria that's in faeces basically.
feces?
Well, it can be in human faeces, bird faeces. There's a range of places it can come from, but the paratyphoid, this particular paratyphoid is a human sourced paratyphoid.
So it's human waste.
So it's human waste is the indications, and there are a number of ways. Just the earlier discussion we had about where it could come from. One of the most obvious ones is that there are people who are living aboard vessels, and if they don't have adequate containment and then removal of that waste, then that could be one of the sources.
That is the most likely source. Paul.
Thank you, Chair. Just a question on that. Can one of the staff confirm that the harbour master is doing some work to get a handle on these boats that are more permanently at that marina, or some solution to that?
So, look, I discussed this with the Chief Executive of the Napier City Council the other day. The Napier City Council has taken ownership of this issue, and they are working directly with vessel owners and the sailing club around the expectation and the change of requirements and the processes that will be used to verify what is happening on those vessels. So, essentially, they are doing it. So, at this point, we don't feel the need to reach across and put a compliance exercise over the top of what Napier City Council is doing.
Yep, thanks for that, James.
Mr. Chair. Mr. Chair.
Yeah, sorry, you will have to speak up because big table.
Mr. Chair.
Thank you, Neil.
Can the Chief Executive outline the powers that Napier City has got versus the powers the Regional Council's got in regard to that particular water zone?
Our powers principally reside around events after they happen, if you like. We've got to catch somebody not complying. As the owner of the marina, they can set contractual expectations on vessels moored there to whatever extent they want to dictate. So, in a sense, they are the ambulance at the top of the cliff, whereas we're the ambulance at the bottom of the cliff. And you'll appreciate that undertaking compliance to catch a vessel discharging from its toilet waste, which one would expect might happen in the early hours of the morning or at night, and will be subsurface, is something which is particularly difficult to do, and so the most cost-effective and practical approach is to ensure that contractually all vessel owners are required as part of their mooring licence with the Napier City Council to give effect to the rules, and for Napier City to police that. But
Can you tell us if there are any powers to enter a vessel and to to verify that it has appropriate wastewater capacity?
So we do have general powers to do that where we've got reason to believe that there may be an offence. So the short answer is yes, but obviously there would be a legal test around us having reason to believe. Conducting a broad surveillance program by just going and visiting every vessel, I would need to check on whether we would have the power to do that. I suspect our initial approach would be to seek the voluntary agreement of all the vessel owners for us to come and check out what they're doing, if indeed that is necessary. But as I say, at the moment it's with Napier City Council, and if they provide us with advice that they don't believe they can resolve the issue without us using our enforcement powers and coming in over the top, then we'll take that request from them and respond accordingly.
Yeah, I hear what you're saying, Mr. Chair. However, there is the issue of the policeman appearing on the scene is often a dissuader in this regard, and whether we can be proactive and support Napier City overcome this problem. I would be interested to know whether we are planning to participate in policing and enforcing this whole situation.
So look, that's a matter I'm more than happy to take up with Napier City Council and with our compliance staff and come back to you with a view.
Thank you, Neil. Any other on the follow-up?
If I could follow on, Mr. Chair, in regard to compliance and monitoring in other sites around the estuary, is there going to be a continuation of increased assessments made of particular point discharges of some of the drains and streams going into the estuary in regard, for example, to Campylobacter and other human waste contaminants?
There is a general issue with the quantum of resource the Regional Council has available to undertake surveillance on high-risk resource consents, and there is a proposal coming to the Council as part of the long-term plan to increase resourcing in that regard. We do have some short-term resourcing needs around our compliance effort for some other matters, and we will be bringing a proposal to the Council prior to Christmas around potentially expediting some of the expanded activity in the compliance area ahead of the start of the next long-term plan.
Okay, do we have someone to move that we accept the follow-ups? Thank you, Peter. Seconder, Paul. All those in favour? Aye. Thank you.
Are we not live today? Are we not being recorded?
I have no idea.
Just the TV's not on.
I never look. Okay, so we'll move to item 5. So minor items not on the agenda that people wish to bring to the table. Mr. Mohi?
Communication back to Hapu and Marae.
I'll report on our meeting in Wairoa yesterday, the Tai Whenua. Yes? Terms of reference, minor item. That's on the agenda. Yeah. Are you happy to leave it on the agenda, or do you want to?
No, that's fine.
Okay. Right, so with 3 minor items, so we'll move on to the decision items, and we'll start with Tukituki, Plan Change 6. Then the Dominion can leave, I guess. Right, who's taking us through? Oh, Tom, thank you.
Thanks, Chair. Kia ora koutou. I actually had anticipated not being here today, so Gavin Ide had prepared a presentation, and it's a better presentation than I was probably going to give you, so I think it's better that Gavin speaks to his presentation, and then happy to be involved in the discussion and questions.
Okay, floor's yours, Gavin.
Morena, everyone.
So just a few slides to give this presentation and the paper a bit of a structure this morning. So for the most part, I'll assume that the paper's been pretty much read. But just to take you through why this paper is in front of you today. In August, the committee had asked staff to come back to the planning committee meeting, as it turns out today, to come back on some options around what might be a narrow plan change to address some urgent implementation matters around Plan Change 6. And then members will also recall that at its last meeting, they received a presentation from some delegates, representatives from the Central Hawke's Bay community, amongst other things, calling for or asking for a postponement in the date for when new minimum flow limits within Plan Change 6 would come into effect. So that's just a bit of context, and that's what's really been the focus of this particular paper before you today. I'm conscious that perhaps it might be read by some as not going far enough, or they might have expected perhaps from the headline that it might have covered a range of other things. But for absolute clarity, I want to point out that there's a half dozen things, if not many more things, that this paper is not. It's not a revisit of the RWSS in any way. It's certainly not re-looking at Plan Change 6 in its entirety. We were given instructions from the committee to look at a focused plan change, so we're not looking at a substantive revisit or overhaul of many of the provisions within Plan Change 6 already. Certainly that touches on the ins and outs of the water quality limits within PC6. It's not around the preparation and supply of farm environment plans, and it's not about resource consent issues already within the catchment in terms of compliance and historic non-compliance type issues. It really just does come back to those two key drivers. So the paper itself is structured into two parts, and perhaps, Chair, it might be helpful just to stick through these slides in the first instance and then take questions after that, yeah? Okay. So part one, that's focused on this issue of potentially deferring the minimum flow limits, or deferring the date when minimum flows will come in. The new minimum flows will take effect from July 2018, that's next year. The option is perhaps to consider a plan change to modify those dates. But there is no resourcing in place, staff time or external expenditure budgeted for any kind of plan change like this to be factored into our existing resource management work program. We have looked at the possibility of this new SPP or streamlined planning process that recent amendments to the RMA have brought about. But the paper says that new streamlined planning process is really only worth considering if the proposal kind of gets a good deal of support from the key players being the likes of iwi authorities, those parties who have submitted, particularly on past resource consents, like Fish and Game and Forest and Bird and Department of Conservation. No matter what we might do with the plan provisions themselves in terms of minimum flow dates, you would still, or somebody would still need to circle back round and change the consent conditions for water takes within the Tukituki. They also need amending, and that's an entirely separate sequence of events altogether. So just thinking about the timing and resourcing implications of this part one, the minimum flows, possible plan change. As I say, no budget in place. We have assumed that this is all that this plan change would do or seek to do. That is defer the dates for the minimum flows. As tempting as it might be to add in some extra bits just because we're doing a plan change anyway, this These costings and timeframes are all assumed to be just a plan change on the minimum flow dates. If we were to pursue a streamlined planning process, because there may be support for it out there in the community in terms of content and process, I've estimated that you'd be in the order of $100,000 to $150,000 in terms of staff time and external costs. With the streamlined planning process, there are no Environment Court appeal phases proceedings. So that's an absolute no extra costs in terms of that streamlined planning process. Looking at the steps that are required to go through in a streamlined planning process, it's streamlined, but it's certainly not swift. You're still contemplating something in the order of at least a year by the time you do your homework, you do your Section 32 evaluations, you draft it up, you put it out for submissions and go through your decision-making process. So don't for a minute think it's just a matter of weeks or just a few months. It's a little bit more than that. CPC or council initiated plan change, the costs around that we've estimated to be in the order of 120 to 200,000, but that does not include the possibility of Environment Court appeal costs, such as experts, evidence, legal advice support through mediation and potentially even formal Environment Court hearings. So yeah, certainly looking upwards of that figure there if there are one or more Environment Court appeals. Time frame for that, again, is not swift. Around about 18 months would be my best guess, but then a big question mark about what happens beyond the 18 months if there are any Environment Court appeals lodged. Common theme coming through here, nothing happens overnight. Part 2. So this is around the question that was posed by the committee members back in August to staff. What might be some of the options around a narrow plan change to address some of the urgent implementation matters? And so we've gone through, amongst some of the key practitioners of staff, gone through a bit of an assessment, trying to weight, score, test some of these ideas, candidate ideas for a plan change to address some of the implementation issues. Actually, when it comes down to the crunch, there's only a few really, really urgent things that need to be or could be addressed by a plan change. There is a range of other things that could be addressed by a plan change, but they're not necessarily as urgent. The upshot is that those limited urgent matters would be around some amendments to accommodate changes to Overseer. It's a software product by a third party that the third party updates from time to time throughout the year. Our planning provisions pretty much locked in at a well and truly outdated version of Overseer as it is already. The other items there that could be added on are just a simple requirement for farm environment plans to be provided to the council when the council requests a copy of them. And then there's an issue in there around the stream depletion regime within policy TT1. On the face of it, crikey, it's hard to unpick as it is, but there is a little bit of a gap in there, so it'd be nice to tidy that up. So while there are, again, no budgets in place for staff time or external expenditure to accommodate any of these sorts of Plan Change 6 implementation issues by way of a plan change, there are some potential future outputs on the outlets on the horizon for contemplating some of these fixes. One is, and this is what's recommended in the paper, that the council considers resourcing such a plan change through the upcoming long-term plan process. But in any event, further on down the line, we've got the prospect of the more fulsome Regional Resource Management Plan review, currently scheduled to commence in 2020-21 financial year. And beyond that, in 2025, policy GT5 and Plan Change 6 already anticipates that the council will need to circle back around and reassess whether PC6 needs to add or modify some of that regulation in any event. So that's like 2025 would be 10 years beyond when Plan Change 6 itself first became operative. So that's an inevitable 10-year planning cycle anyway. In terms of Part 2 matters, these urgent implementation items, the staff's view is that the streamlined planning pathway or planning process is not the ideal process right now. This whole SPP thing is relatively new. It's certainly untested, and it's not something that we'd sort of perhaps prefer to be a guinea pig in with this wide array of Plan Change 6 implementation challenges. Council initiated plan change for these sorts of things. No, this is Part 2, the Plan Change 6 implementation challenges, not the minimum flows.
Oh, okay.
Yeah, does that clarify? If this was a council initiated plan change, again, you'd be looking in the order of at least $200,000 to work your way through plan change preparation, notification, submissions, decisions, or hearings and decisions, and so on. All of that does take time. Estimates are based on past experiences. You'd be looking at something in the order of 2 years to work through those drafting phases right through to hearings and decisions, and then a big question mark at the end as to whether there's an Environment Court appeal phase as well. The paper also just reminds committee members that in terms of just simply notifying a plan change, that is releasing it and inviting submissions, the legal effect of that, certainly in terms of rules, is not immediate. It does not overwrite what provisions are already in the plan, and it certainly does not automatically modify anything within the existing resource consent conditions. The council only has the ability to review existing resource consents after a plan change becomes operative. It does not have the ability to review consent conditions while a plan change is only in its proposed form or proposed state. But consent holders can apply for a change of conditions at any time. They're not constrained by the proposed plan and operative plan state. Certainly the fact that there is a proposed plan change in the wind could be a factor that is taken into account by the council in its compliance considerations and compliance action. And one thing to really re-emphasise is, the paper says it on several occasions, despite all your best endeavours to draft a plan change and notify it for submissions, the timing beyond that and certainly the outcome, you just cannot give any guarantees as to what the outcome will be, because that's subject to due process through public submissions and potentially even court challenges depending on what process you go down. So that's a real reality check that needs to be stressed. So just turning to the recommendations then of this paper. In terms of first and fundamental thing, the fact that there are no resources currently in place for either a minimum flows plan change or a Part 2 implementation issues type plan change, that raises some big question marks for the council, if not this committee as well, around the Local Government Act requirements for decision making. That's entirely separate from all your RMA considerations. So recommendation 2.1 flags that for you, and hopefully your deliberations will turn its mind to those factors as well. Recommendations 2.2 and beyond What we're saying is we're recommending the committee tasks the staff to go away and have some further conversations with some key players in relation to this prospect of the minimum flows being delayed or postponed, and testing whether that proposition meets a degree of support from the key players or whether there's strong opposition to that whole proposition. And we'll come back to you with the results of those conversations at the December Regional Planning Committee meeting. And in relation to the part 2, the implementation issues, we're recommending that the council, or committee in first instance, and then council gives due consideration to that as part of its upcoming LTP discussions.
Thanks, Gavin. Questions? No, we can't.
When you're ready.
Okay, you want to move when you're ready. Okay. Yes.
Just want to make a couple of additional comments. Obviously, in terms of the flows, the issues that we're flagging is that if this is a path that you want to go down, timing's of the essence, because the flows bite in the summer of 18-19. So the timeframes are important, and that's why we've made that recommendation if you want to go down that path. The other factor there is that if we do go down that path and signal the intention for a plan change, that does create some leeway if we get closer to the time in terms of the matters that Gavin's raised in terms of a Section 127 application by consent holders to effectively to vary the consent conditions that are sitting in their water consents, or the approach we take to compliance. That's helpful in that regard. The second thing in terms of the flows is that we signalled on the 4th of October, I believe it was, that obviously stakeholder support is very important in terms of going down that fast track process. So to that end, on the 24th of October, Ian Maxwell and I met with local representatives of Fish and Game and Forest and Bird, and that meeting was, in my view, very constructive. The steer we got from those representatives was that they understood, I suppose, what you might call the natural justice argument as why the water users were asking for this move from this committee, and but they were also very clear that they wanted this issue to be ring-fenced and ensure that we were really talking about dates, that there was absolutely clear that there was no issue in terms of the flow regime itself. So I just feed that back to you. Obviously there will be more discussions with wider groups and going back to them. The second, in terms of the implementation matter and specifically around overseer, the paper does flag that the use of overseer in freshwater management is a national issue, and there's a chance. We don't want to express it in the paper as a risk because that might be giving you a false steer, but the advice that we've had from staff is that at some stage the issue around overseer is probably going to get traversed, taken to issue by a consent holder. And because this council sort of sits at the forefront in terms of PC6 and probably the way overseer has been dealt with by the Board of Inquiry, there is a risk that we will be litigating or relitigating or having a deep dive into overseer at any stage. And so part of your deliberations could well take into account the fact that is it something we want to deal with proactively over the long term, or just wait until it is visited upon us through an adversarial process, which actually doesn't get us any closer to a solution. So.
Just want to tease out a bit more about what's involved in the streamline plan change. You were saying that you shouldn't, or you were recommending that we shouldn't really consider it unless the vast majority of the people who might be submitters were in support of what was being proposed. Is that correct?
Yes, correct, yeah.
So what happens if 2 or 3 are opposed? I mean, what does the vast majority look like, and what happens if some people are opposed? Because I gather they have no right of appeal.
No, that's part of it, but in any plan change type of process or proposal, any person still has the right to ask questions and take a judicial review type case through the courts. That's not an Environment Court appeal on the merits of the proposal itself. It's a procedural challenge on process. That looms large no matter what process you follow with your plan change.
So what's the basis for such a...
Yep. So the potential risk to follow one of these new streamlined planning pathways is because of their relatively unknown being, they're new, and that they, at their bare minimum, would certainly have a lot more reduced public participation than your standard council plan change process. There's the risk that with that reduced public participation, some parties might feel aggrieved by that and ask or take challenge against the council following a streamlined planning process if you don't duly consider the consequences of the process choices. Does that make sense?
Thank you, Gavin. I just wonder whether you could comment on the treatment of a breach of rules being temporary or marginal. Is it possible that we could deal with this issue, say in 2018-19, we're breaching minimum flows? Could we treat that as a temporary breach or a marginal breach?
Just to clarify, the breach of the minimum flows, the river, the flows in the river will go below the monitored level.
That's right.
Is that the breach you're referring to?
Yes. Yep.
Or the point at which the breach is a breach of the consent condition because someone's
the
taking
minimum
water?
flow triggers a consent condition, so you can't draw water because the minimum flow has materialised. So could we treat that as a temporary, as the conditions, the amended legislation enables us to treat as a permitted activity a breach on a temporary or marginal basis? Could we in fact deal with this by using that mechanism to get around it?
Councillor, I'll give a view. I think the short answer is no. So what was had in mind in terms of those provisions within the Act were very minor matters, and I don't think this would meet that test. The flow regime is pretty fundamental to the plan, and the irrigation bans are pretty fundamental to the overall schematic of the plan. And so we're getting into very difficult territory to take a discretionary decision essentially not to enforce. If we have, as foreshadowed in the paper, if we have a plan that's well advanced and signalled to shift the dates, then there will be a whole bunch of considerations that I will need to weigh up in terms of deciding whether or not to take compliance action in relation to anybody not fulfilling their resource requirements or resource consent requirements in terms of coming under the ban. To take the step to publicly decide not to enforce the ban, which at that point is still a matter of law and still a requirement of resource consent, would be a very high risk step to take, and I would expect there would be a very high probability of a judicial review being taken of that decision.
I hear you. However, have we explored or received an opinion about the meanings of the word temporary or marginal that would guide your decision not to enable the...
No, we have not, and that is something we could explore with our solicitors. I'm just giving you a view based on That's right. Just based on what I understand was the policy advice that went to Cabinet around those provisions and what was had in mind. I think you were talking about very minor things on an individual property basis rather than a minimum flow in a river, for example, which is pretty wide scale.
Just in addition to that, Councillor, look, as a part of this paper, we did get a legal view around the mechanics and the process of this. It doesn't speak to the point around minor and temporary that you touch on, but it supports the Chief Executive's position is that, without a signal intention of a plan change, it would make, non-enforcement or non-compliance, problematic for the organisation.
Brief questions. The paper talks about Central Hawke's Bay, but isn't it in effect a variation for a discrete, identifiable number of irrigators? And if that's the case, how many are there?
From memory and a footnote in the paper, I think overall there are 100 consents, 76 have the condition in them, roughly 50 surface water takes, a further 6 stream depleting, high stream depleting effects, so there's 56, and then there's another 20 that fall into a category where they get stepped down to 50% in the event of a ban as opposed to a full ban.
So in effect we're talking about 76 irrigators here, a plan change for 76 irrigators. My next thing is, the question I have for you is this: what will be different? So it's being asked for an extension of time, but why I haven't had any explanation here. What will be different? Time to do what? What is the different outcome? What is there to be? I want something specific. Just said all we've got is, we want more time. Time for what? What is expected to be different? What are the plans? And what is concrete going to happen if there is a plan change for 76 irrigators?
I would like to answer that. Were you here when the Mayor of Central came in?
I was. I listened. My question is in the light. I've heard her presentation now twice.
Okay.
In the light, this is an informed question.
The chap she brought in, the CEO of a big farm down there, he said in his speech, he said they wanted time to reconsider other water storage options which they hadn't considered because of they were going to do Ruataniwha. So that's what he wanted, the extra time. He said to even get the consents in place, it was going to take considerable time. He spent a lot of time talking about it.
But with respect, I mean, we have to have a critical analysis of this. We're being asked to expend a lot of staff time, put ourselves in the, and I want to know what is different. And of that CE, everybody knows that when the RWSS was first promoted, it was touch and go whether it was going to happen. And I would have thought a prudent manager would have said, Plan A, it works. Plan B, it don't work. In the event it don't work, here's my plan, what I'm going to do. What he effectively told us was he gave no thought to Plan B. And when everything fell to, he's now to turn up here and say, we want more time. Well, I want to be convinced that the sort of time that he should have been putting into planning the Plan B before is going to be done in this time here. I don't want to get to the end of this period and have the same things raised again, we need more time because. If I'm going to be asked to consider this, I want to know with some degree of specificity what's going to happen. So, Rex Graham, you want 5 years? What are you going to do in 5 years? You tell me. And when you've told me, I'll then think about it.
Fortunately, this doesn't affect St George's Road, but...
No,
I know what you're saying, yeah. We'll take Debbie, then Peter.
Can I have my answer?
Oh, I think that was that.
If I can...
So I did speak to the Chief Executive that you're referring to this morning and basically put that question to him, not anticipating it would be on your behalf, Councillor. The answer I got was in terms of in terms of were they asleep at the wheel, the answer I got is they were extraordinarily focused on Ruataniwha and perhaps, you know, with the benefit of hindsight, too focused on Ruataniwha, and that, and he front-footed the issue that had Ruataniwha proceeded, there still would have been a period where the minimum flows would have kicked in, and so there was potentially always a conversation coming with council around the interim impact of the minimum flows. Now, what we're dealing with here, what we would have been dealing with then, is a discussion around how we're going to enforce the minimum flows, knowing that down the track, those that had chosen to take, you know, had acted proactively in terms of the water, were going to manage that via that, and that would have been a discussion around enforcement and compliance, knowing that the Ruataniwha was starting. Now it's potentially a discussion around enforcement and compliance based on your decision, whether a plan change is coming. In terms of the other aspect of that is that what they are asking for, and I think what he presented at this meeting was, they want time for decent solutions. This is in terms of if we don't have time, the risk is that we all go off to our own corners and find the best solution for our individual properties or businesses, and that could be, and there's a range of ways that could be dealt with, and the feeling is that maybe this bit of time buys us an opportunity to get some broader, more community-based solutions to what they're facing.
Thank you. I just note too that those parties were contractually bound to Ruataniwha Water, which adds another complication to why they weren't actually investigating other options. Hindsight's a wonderful thing. My question to you, I'm not sure if it's James or Ian, if all of the irrigation bans came into effect and this was put in place with the idea that there would be stored water to supplement those flows, is there any guarantee that we're even then going to hit the increased minimum flows, and what will council do in that situation?
So I can give you an initial view, and I think it's really important to understand that the policy is not designed to maintain flows in a river. Could never do that. It's Mother Nature will dictate where the flows in the river go. What the policy does is it says at a point that makes sense for a whole bunch of reasons and is locked in policy, the human-induced effects of taking further water should cease or be wound back. That's the intent of, they're called minimum flows. I prefer to call them management flows. It's a management response. Flow is reached, stop taking. The river may well go beyond that flow and carry on well down, depending on the climate and the weather at the time, and we've seen plenty of examples of that previously.
Thanks, Rex. So correct me if I'm wrong, but under Plan Change 6, there is provision for emergency supply at, I think, of a level of 50% of consented volume. If we're going to spend $120,000 here on a streamlined plan change, or the other possibility, would we not be actually better off to spend that money getting these people organised into some sort of a global consent for that emergency supply that's currently available under the plan change, and get them to work cooperatively on how to manage that reduced volume? And I want to know whether you've considered that as an alternative possibility.
So just to ensure we've got the terminology right, I believe that the emergency water provisions are different from the 50%, and so it's a matter of if you're the extent of your connection as a groundwater taker, and I think that's the 20 I mentioned before, that if you are considered one step removed but still affecting the river, that's when you go to 50%. The emergency water is water that's available for crop survival, I believe. And it's mostly downstream. So I think, there has been some applied for, and so look, in part the question is possibly both that look, there are a range of mitigations that were loaded into PC6, and they've been traversed in previous papers to offset the impacts of the new minimum flow regime. But you're absolutely correct that those groups wanting to bandy together to come up with some solutions, it's just can they do it in the time frame that they've got.
To me it still seems to me that it might be a better solution than going through some form of plan change. I mean, that's what it's there for. We want to get these people to work together cooperatively, and this is an opportunity to do so. It's worked really well in Twyford, as we all know, so I don't see why we wouldn't try and take that model to other parts of our area.
So Councillor, you'll recall that we have tried to engage with them on it unsuccessfully. We are engaging with the Ruataniwha Water Users Group, and we do have staff in the building whose focus is the user groups, and we're going to keep pushing to them that this is available. We're happy to help them set themselves up to work, to bring it together. It's really kind of getting the horse to water. They have to decide to drink it.
Well, I tell you, if we say no to any plan change or delay, that'll bring the horse to water for sure.
Well, I have a couple of questions. The first one was along the same lines. I don't have that paper in front of me, but the original paper we were brought listed 4 or 5 options within the current rules regime that provided escapes of one sort or another from draconian application of the low flows. And it does seem to me that we are owed a hell of a lot more analysis of what traction those would in fact have, what degree of relief they would in fact have if they were actively pursued by these guys. And there is nothing like the threat of no time extension, you would think, to get these 76 consent holders to get their minds at work on the issue. So I guess that's more a comment than a question, but it does represent another alternative avenue to pursue. My questions have to do with this streamlined procedure. We were sold a streamlined procedure on the Ruataniwha Dam, weren't we? And we saw where that got us. So much for streamlining. The notion here, as I understand it, is that you file an application, the minister, now David Parker, decides whether he wants to accept it, what discretion is there, and who do we think David Parker would pay attention to, and how would he go about assessing whether he wants to accept it?
So, new government, new ministry officials have a lot of uncertainty at the moment around that new minister's appetite for many of the RMA things, let alone this new streamlined planning process. So, hence, one of the recommendations being in this paper to suggest staff go away and have some further talks, particularly now the government's formed, further talks with MFE officials to try and have a better line of sight around the new minister's views on this streamlined planning process.
Views aside, we've been told in the Water Conservation Order, which our chairman is very adamantly upset about because it's ministerial involvement in local government. In this case, we were told that, in that case, we were told the minister really had no choice. It was a box tick. You fill out the form properly for a WCO. The minister really has to accept it. Is this what we're dealing with here? Same kind of, fill out the form properly and.
I think it's a bit of a hybrid, I suppose. Sorry.
We are just what is recommended here is that we're going back and we're talking to key stakeholders that will either agree or disrupt this. That's basically what we're saying here, isn't it? And how much it's going to cost. So we're not at the minister stage yet, are we? You wouldn't thought? You're not going to.
No, but certainly the advisors
the
to the minister.
Is being laid here for a quote streamlined process that is going to actually create a benefit for 76 consent holders, and so I do think a little more clarity as to what this process actually is like. If one of my constituents were to come to me and say, "Do you want to give up your rights under this streamlined process to go to the Environment Court?" I would say, you're crazy to do that.
That's what we're going to
And
find
so,
out.
but apparently we're going to talk to some environmental groups and maybe some iwi too, who are going to say, no, we don't care. We're happy to give up our rights to appeal these kind of matters that we fought 6 years on and went to court on previously. We're going to happily give up our rights of appeal here so that you guys can have a streamlined process to benefit 76 consent holders. Good luck with that.
But, Tom, that's what we're going to find out, isn't it?
Yeah,
That's
well,
what we're going to find out.
I think we
Tanya,
know.
what do you think you know, right? Tanya?
Kia ora, thank you. I guess a question for Tom and Gavin. Of the 76 irrigators that you've identified, do we know how many of them have actually made alternative arrangements to deal with minimum flow? I mean, we've heard from the people who are saying this is a big problem for them, but of the 76, have you analysed how many of them actually have made alternative arrangements or will have made alternative arrangements by the time the minimum flow kicks in? I have a couple of questions, by the way, that's one.
Okay.
I have not done a consent by consent analysis.
And can I just point out yet again, as the paper tried to say repeatedly, there's no budget, there's no resource allocation for any of this, so we don't have any staff deployed in doing deep analysis on any of this. So part of getting a signal today is if you want that analysis done, we'll go away and work out how we can resource it.
Great. I'm just trying to get a gauge on the information we have to base this decision on, given that even staff going away and having those questions or having that discussion is staff time away from what we've already agreed staff should be doing. So that concerns me. The second of my three questions is we've had discussions with Forest and Bird and one other. I can't remember exactly who the appellants might have been in the Plan Change 6, but I'm assuming Neki was in the mix. Yeah. So has anyone had any discussions with Kahangungu on this yet?
So that's the intention, and there's also the Department of Conservation was a submitter on the consent reviews in the first place. So that was our initial cohort of people. We've spoken with one stakeholder ahead of this meeting.
Yeah.
The others are to come.
Yeah, because I'm expecting that those parties that were strenuous in the PC6 process are expecting that the council, now that that process is completed and Plan Change 6 is actually operative, that we will stand by it. So my last question is just bringing it back to a reality check. You've given us a couple of options. One is the fast process and another one is to explore the standard change process. My question to staff and perhaps to James is, the reality check is, how certain can we be that we're going to even accomplish those plan changes within the time frame needed so that they can be operative by the time that we will be seeing the minimum flow regime coming into effect?
So in terms of that question, I believe the strategy is that, well, hopefully as we represent it to you, if you want us to do this, which has got to be the first part of this process, is we're asking you, then time is of the essence for this issue. And so outside, if we can't get a steer or some confidence around the fact that we're going to put this into a fast process, that we get some feedback from the ministry officials that this is a candidate, and it is, so that is, that is a gate, a decision gate in this process. We need that process to be underway to give ourselves the leeway should the process spill over time. So the plan doesn't necessarily have to be operative, but if it's well advanced, it does give us some other leeway in terms of consent holder applications for review or enforcement.
So if we're not successful in the fast process, which I think would be pretty dicey, to say that we could pin our hopes on that, if we go through the standard process, in your experience, can you nail a plan change in 12 months?
So in terms of the issue on flows, we haven't made a recommendation that if you can't get the SPP process out of the way, that you go to the second process.
But it would be very slow. Thank you, Mike. And then Paul, back to you.
Just for the Maori members to put it into context, so I'm representing Tamatea 9 hapu in this context, and while we say there's 76 farmers involved, virtually none of them are Maori, but there's hundreds of jobs that come from those 77 farmers, I can assure you of that. So it does affect tangata whenua in the Tamatea area. As far as Councillor Barker's saying farmers didn't have a plan B, this was because the regional council staff were so good at convincing them that the dam was going to go ahead that why bother with a plan B? So, all jokes aside, it was only in the last couple of months that the penny dropped that no, it's not going to go ahead, and that was a huge shock to Central Hawke's Bay. So I would just like to say, even if 2 months ago or whenever the decision came out, they started to make a plan then, those plans would take a couple of years to put into action. And things like on-farm storage, which is very borderline economical, a lot of them would have to are going to have to change their farming practices from because this restriction on water will happen in the summer of 2018. Did you realise that?
Thank you, Chair. A statement and a couple of questions. Very briefly, Tom and Gavin, I'd like to thank you for the slide you put up at the beginning of the presentation where you noted the things that weren't included in this paper, because that was something I'd raised some concerns about, especially around, for me, was the disconnect between the DIN limits in the Tukituki and the proposed leaching rates under Plan Change 6. But as you've pointed out, that's actually a major thing, not a minor thing, so it falls outside the gambit here, and that's fine. And the other one I had concerns about was that the 15 million additional cubes has kind of been opened up with HBRIC handing in that resource consent, and again, the feeling that was something that wasn't part of the of what was being discussed in this paper, and that's fair enough. I accept that, but thanks for putting that up. So that's cool. My first question is when you say you've spoken to Fish and Game and Forest and Bird, I assume you're intending to go down and speak to not only just the locals here, but also speak to Wellington about that, the head officers.
So look, in respect of Fish and Game, I mean the discussions are initial, and they were happy that the conversation's local at this stage. In terms of the Forest and Bird representative, he made the point that he was duty bound to be reporting the meeting back to his head office, so that engagement is probably in play. And
to be clear, Councillor, in terms of Fish and Game, it's the there are, I have to remember now, 13 independent. Legally independent business units of Fish and Game. So the national office has no role to play in this. They would simply provide funding for it if it was chosen to be taken on by the local office. So the decisions are made locally by the local council on any consents that they may wish to get involved in. It's not something that we would necessarily have to go and talk to the national office, because there's no hierarchy there. They're just another office of Fish and Game. And we also did invite the Te Taio Forum members and Central Hawke's Bay Forest and Bird folk, but they were unavailable for that meeting.
Thanks for that. Now my second question is, I was told some time ago that I was able as a private citizen or an individual, whatever, to initiate a plan change myself at my cost. Does that situation apply under this streamlined process? So these 76 irrigators who are affected by this minimum flows regime, they are actually able to apply for the streamlined process at their cost rather than ours.
No.
No. So
Section
any-
80C.
any
sorry.
person can apply, or any person can request a change to a regional plan or district plan of a traditional process, and also the streamlined planning process is open to private people to request it as well. But there are a few extra tests and steps involved. And in terms of where the costs fall, you're right, councillor, the costs would fall for the most part, and the preparation of those plan change requests would fall on the proponents themselves.
Gavin, I just have a quick question. So this is, what you're asking here is permission to start a process of discussing with the other stakeholders and working out where everything's going to fall. That's basically what you're asking. So it's a real initial stage. How much is it going to cost for this stage of the, 'cause we've got no allocation of budget, how much just for this bit?
For the most part, I think that's going to be a factor of staff time. Maybe a bit of legal advice to support some avenues that we might need to pursue. And if we're intending on reporting back by December as the next iteration of the conversation, there's not that much staff time available between now and then to invest. So I'd say, the number right, a few hours at least.
Fenton. I know, this is what we're doing. We've got a global attitude.
There we go. Thank you, Chair. Just a question, talk about unbudgeted costs. I'm assuming, and I need clarified, we're going to be up for costs of compliance and monitoring anyway, aren't we?
Yep, we've got significant increase in costs for implementing Plan Change 6 around compliance, and there are proposals coming to Council in the long-term plan to fund that, which involves additional consents and compliance staff.
Hey, we have enough questions, I think. We have a mover and Councillor Hewitt. Do we have a seconder? Councillor Wilson? We have a seconder. So, Debbie, do you wish to speak first?
Thank you. There's always going to be emotion in the debate around anything that's legacy from Ruataniwha. So the discussions today are not surprising. One of the key things I'd like to remind the group is that in the absence of a stored water option, it's going to be very, very difficult to be increasing minimum flows in any of the catchments, and that's not just the Ruataniwha catchment, but the same thing will be coming into the Hiratonga catchment very, very soon under the tank process, I have no doubt. So just to pause there, I'd also like to remind the group that this request, although it's been led by a delegation from Central Hawke's Bay led by the Mayor, it's not just about 76 consent holders, it's a wider community appreciation that we're discussing here, and I would like to think that there's quite a bit of compassion around the table for the situation that a number of people downstream of those 76 consent holders in the economic cycle will be potentially facing, because the negative impacts will be on the wider community as well. I've heard some concerns about, look, what are the landowners who are going to be severely impacted by this increase in minimum flows doing, and I can hand on heart assure all of you that they are not sitting resting on their laurels. There have been regular meetings ever since Ruataniwha has been put to rest by this council, from the water users group that I've been at, and look, the discussions, and they've been supported by staff here, which I'm very grateful for. They've been around, look, some of the more interesting options now are aquifer recharge, and how could we look at that? Harvesting of winter flows, which is one of the Tukituki options in the existing plan change, and staff have been working on that with local farmers. Global consensus been coming up. Tranche 2, that only became public last Wednesday, that had been released from HBRIC. So the water users group, they're meeting next week, but they're only just getting a feel for what that may mean. And I know James has met with one of those users. On-farm storage, water storage options are being discussed again. So So while in the current state that Ruataniwha water users are still contractually bound, and I note that contractual binding is still current to this day, I can assure you that these people are business people and they're not sitting around and not doing anything at all. So I just, look, at this point in time, I hear that there's a lot of concerns around the table, and we're not selling this hook, line and sinker, as our chairman has said. Rex, look, we're just discussing. Let's have another look at this and come back and see how it's looking in a month's time, and maybe you might be getting a feel back, Tom, from the NGO community that this isn't really an option, and then we come back and discuss it. So it's just about giving the community a little bit of breathing space and not actually killing any options at this point, which is right here today. So I have one concern. I am very cautious that the Ruataniwha catchment, or the Tuki catchment, seems to be the test case for too many things from this council. So, you know, I'm stepping into the streamlined planning process with caution as well, and hopefully everyone's got their blinkers off on that, because I don't really like our catchment, our community being the test case as we have been for the first of the plan changes, and on it goes. So yes, I'm hearing concerns around the table for that, but I'd just like to thank all of the members of this committee for their respectful consideration of this really serious community request. Thank you.
Hey, Debbie Fendon.
Oh, just very briefly, Chair. I mean, if you go and have a reread the recommendations, all we're really being asked to do is unleash the staff to go and get us more information. We don't have enough to make a decision on whether we should be even attempting a plan delay in its simplest form. I think it's going to be pretty tough. I'm not extremely hopeful that we would get it off the ground, but we're not being asked to make that decision today, luckily, and I'd have to be against it today because there's not enough information on the table just quite yet. But I expect to see a whole lot more for us to digest and consider on the 6th of December, and I'm happy to support the recommendations as they are written here.
Thank you. Peter, then Mike.
Yeah, Chair, I'd like to move an amendment to the motion that we're currently considering. I'd like to add a 2.4, which would read as follows: directs staff to report back to the RPC on the range of options currently available to consent holders under the provisions of Plan Change 6.
Are you happy with that?
I'd be happy with that as the mover.
So we'll add that in as the substantive, okay?
Do those options in your mind include the affected parties considering their own change or
No, not
Well,
suggesting.
I could.
That's not currently available under Plan Change 6 though. So in that case, I don't need to speak, Chair.
Okay, we're going to add that. So we're going to add 0.24. I don't know if we can get that on the board just to make sure we're clarified. Mike.
Given that, I'll won't speak.
Any other speakers? Councillor Barker.
I'd like to move a further amendment that, in addition to the further advice that Peter's got, I haven't got the words down yet, so I might do Judy's attention at some stage, invite the affected parties to put a submission to council in what they would hope to see achieved by such a delay. So if they're asking for an extension, they should be able to say what they intend to do and do differently. They can come along and tell us. So we then have a complete picture and not just ask for a delay for the purposes of just having a delay.
Debbie, would you be happy with that? Not happy with that? You don't want them to come back?
Oh, yes, but
It's a 4. It's pretty obnoxious.
Can we just take a bit of... If I can just say, it's a really, really busy time of the year, and it's really important to these people, but they've been once, and maybe it could be incorporated in what the staff are doing in the next month, because I know that some of the staff are meeting with them on the 9th next week. Could they just come back with a report, or?
Well, I don't care how it is, but I want it. If people ask for a delay, they have done, I think they should tell us what they intend to do and what they intend to have their achievements out of it. If we don't have that, I'm against this. I just want to make that clear. And if they're too busy, to tell us what they want to do. And well, they're too busy for my time. That's all I can say.
I thought they did that last month.
No, they didn't. Yeah, one submission. They turn up, they're all 76, so that's what we're going to do. They can tell us what they are. And if they come along and have that as part of it, so we would know what it was they were intending to do, how they're going to use the time. Sorry?
Are you happy to accept it as 2-5? Might help.
All right.
Fenn, you would? Your seconder would accept it as 2-5?
So you're happy for the mayor to come back?
No, I the spokesperson for the group, but they've got to come back and tell us what they're going to do with some degree of particularity.
I think, Councillor Barker, what you're asking here is what is their plan B?
Yeah. I want to know what it is, what they're going to do, what they hope to
Put
achieve.
it in, we'll put it up and then you can just think about it. Any other, Tanya? And then Tom.
Yeah, just to say, I mean,
Oh, you'll need a second of my amendment. I've moved it. The mover hasn't seconded it.
They're considering what they're going to accept. When I put it up, then the mover will
Think about it.
she's thinking about it and then she'll
Right. Do you want me to write that out for you, Judy? Okay. How about I send you an email?
Tanya.
kia ora. I mean, I wasn't at the last meeting when the presentation was made, but I have heard the commentary today, and it's sad to find that people are in the position they're in. However, I'm not supportive of the recommendations and staff spending their time pursuing this, because I feel that Plan Change 6 is operative, and it was signalled back when the consents were consented back in 2012, 2013. So I think there's been ample time for people to consider their options, and plenty of signals along the way that the Ruataniwha water storage scheme was not a done deal. So as unpleasant as that is, I feel that actually we shouldn't be sending staff off to investigate this any further.
Thank you, Tanya. Paul?
Um,
Tom. Do you mind if Paul jumps in? Paul jumps in, then Tom, and then Mr. Moore again, and then us. Right, we'll go around the table.
Yeah,
Paul.
Thank you, Chair. Yeah, I'm of the view that the delegation from CHB, all these 76 consent holders that have got this issue and asked us to undertake this, are crying crocodile tears. I agree with Tanya that it was well signalled that there's every chance that the Ruataniwha was going to fall over on its own merits, but that decision was taken out of our hands by the Supreme Court. So that, in actual fact, it wasn't the council that canned it; it was the Supreme Court. But in saying that, I'm also very cognizant of the words that Mike Mohi spoke about, how we as a council went down or our investment company went down to CHB and were very persuasive in their arguments about how the chances of the Ruataniwha going ahead. So in that respect, I have some sympathy for the consent holders, and I will support the resolution as put forward because of that. Because I think it's important that the 2.4 and 2.5 are quite an important part of it in terms of giving us better information to make a decision to take the next step.
Paul, Tom.
I will vote tactically for the two amendments and then vote against the resolution. Not a lot of people pay attention to the agenda, I'm afraid I have to say, of the Regional Planning Committee. If this proposal were put on the agenda for the Regional Council meeting, I suspect I would have heard from a lot of people about this matter. I have heard from a fair number of people about this matter who have sent me emails, including people from Central Hawke's Bay, but others as well, who just want to get on with it. They just want to get on with it, and I think it's a fool's errand to hold out this little candle here that a special procedure is going to come to the rescue here. I just can't imagine a large part of our community supporting that. And speaking of community, we've heard from a handful of people and a mayor about the issues raised by this. There is a broader community out there, as I say, not just in Central Hawke's Bay, but beyond Central Hawke's Bay, that want to see us get on with implementing Plan Change 6. And moves like this, to me, are just diversionary, distracting, and delaying the inevitable. And I don't think it's we're doing anybody a service by holding out these kinds of changes. And does bother me, along with Councillor Bevan and Councillor Barker, that there doesn't seem to be any real effort has been made to actually examine what the options are currently under the provisions of Plan Change 6 to deal with the issues at hand. And then it does finally come down to 76 people doing that. So add all that up, and I'm just not sympathetic to the proposal. I'm going to vote against it.
Thank you, Tom. Mike, it's your second dissertation.
No, that was just
That was a question, wasn't
it? I'll just prefix it by saying, do you realise that Tamatea have, with the water conservation order, they have been shaking their heads and saying it's actually quite amazing that almost all of the councillors are agreeing with it, and we are faced with a real tragedy for a lot of our families, right down to the Kohana Reo, if this kicks in next summer. So from that point of view, it's not just the 76, it's a huge community, half of it which has been halved, rushing across to Australia over the last 15 years to jobs, and even more in the future. But they're heartened by comments from some of the councillors, such as we are not going to leave Central Hawke's Bay in the lurch, and also another councillor saying things like we're supporting the water conservation order because it's not going to increase farming. And so down there, we're not going to increase farming, we're just hoping to survive. Thank you.
Thank you. Neil.
Yeah, thank you, Mr. Chair. I'm reluctant to support a consideration of the notion of going for a plan change for the reason that it's unlikely to progress. I'm really concerned that the chances of it not being appealed or there being significant opposition is likely to be strong. So I'm much more interested in the amendment that Peter Bevan moved in regard to let's explore what the options are in terms of consent management under Plan Change 6, including the new provisions. I'm interested to know and interested for staff to get advice as to the meanings of the new legislation on its own, and they're linked to those emergency provisions, which enable those consents to be extended and water to be taken in certain situations. So I'm really interested in what the remedies are should the breach of, or the minimum flows be breached. So that to me is the important part of this. I think the resolution as it stands gives us that period of time between now and perhaps December or even later to bring those answers to the table so we know what we're talking about. And I'd prefer to reserve the $100,000 or $200,000 needed for a plan change amendment to be considered to defend a decision by the Chief Executive to show flexibility in managing those resources. I think there's provision there in the new legislation for the Chief Executive to show significantly more flexibility, and I'd like him and his staff to explore that potential.
Before we go any further, and before you wind up, Debbie, and we may have other speakers, 2.5, are you prepared to accept 2.5? You are, okay. And your seconder was as well. So before you want, are there any other speakers? Then I would like to make a comment. I want to move the whole lot as one. So 1 and 2, and also including 2.4 and 2.5. And I will be supporting it on the basis that we're not going to spend a large amount of money here. What we're going to do is ask our key staff to go out and talk to the stakeholders and say, if we do this, what is your position going to be on this? And that is talk to the iwi, talk to Tangata Whenua generally, talk to DOC, Fish and Game, Forest and Bird, and anybody else who have been deeply involved in this situation. So I don't think there's any harm in that. I think Fenton pointed that out, and I can't see that a month of just seeing whether we can pull this off or not is going to cost us too much money or do us too much harm. Maybe it's going to be an impossible task. Maybe it's not. Maybe everybody thinks that we should be giving these guys 2 or 3 years, or they ask for 5, but it might be a bit of a stretch. But I don't see any harm in us doing this and making a final decision in December, because we haven't got all the information on the table. So that's my position. Debbie, you can wind up.
Thank you, Chair. I'm a little bit sorry that Liz Munro isn't here today, because I really liked the way she spoke last week when she signalled that the local tangata whenua had given an indication that they were incredibly supportive of this request, and therefore so was she. One of the challenges of the Plan Change 6 implementation in this regulatory environment is that every time there was a delay during the Board of Inquiry process, the kick-in dates for anything that was supposed to, be mandated within the process, they were never extended out. So the Board of Inquiry would go on past its 9 months, but everything else, all the other deadlines, they just kept tightening instead of correspondingly moving out. So here we are in a bottleneck, and thank you. We're looking at a bit of time, but I'm very mindful of the fact that people in Central Hawke's Bay are closely running out of time, and they certainly are not resting on their laurels. So let's see where we get with this. Thank you.
Chair, I don't think it's correct that Mr Mohi has a vote.
No.
No, okay, sorry.
I was just giving one.
Resolution alternative now that this has been lost?
Yeah, well, I'm just checking it has been lost.
Okay.
You're absolutely certain it's been lost?
I don't know.
Well, you've got to declare it, Chair. You're the only one.
No, the numbers though. Get the numbers.
Put the numbers up for ask for a division.
Okay, yeah, we need a division, so we get these numbers. It's lost. Okay, we're going to call for a division. All those in favour? Get it? Yeah, get your hand down. Okay, got it. All those against? Resolution is lost. Tania, do you have something to want to?
Yeah, I'm mindful that we had in the paper, in the previous paper, some issues raised around the urgent implementation, and I wondered whether we would be interested in this resolution that we recommend that the RPC direct HBRC staff to include the identified urgent problems with implementing PC6 to the wider review of the RRMP due in 2020. So we can tie up that loose end of the urgent issues that have been raised, being dealt with.
We need to get that up on a board. Can you email it to us?
Yes, I probably can. So, to repeat, recommending that HBRC staff include the urgent implementation problems for PC6 that have been raised into the wider review of the RRMP in 2020. Happy for that to be discussed,
Chair,
but
could
it's
I
just
perhaps
putting that forward.
just make a comment? Look, the advice that Ian's just given me now is that 2020 is too far out in terms of the implementation issues we've got to deal with, and it is our intention that this matter be dealt with in the long-term plan, so be part of our work program over the next 2 years rather than waiting until 2020, given that we are in implementation now. So we are looking at a plan change in relation to plan change 6 sooner than 2020. Yep.
Okay, team, we'll break for lunch. Thank you. So